Assalamualaikum warahmatullahi wabarakatuh. My name is Ali Shafiqah binti Muhammad, 256218. Today, me and my group will be presenting the topic of striking out pleadings in regards of a case review. The case that we chose is Mak Yan Tai and another against Chia Moi King and others. The jurisdiction to strike out or even amend pleadings is provided to the court under Order 18, Rule 19 of Rules of Court. Any unnecessary, frivolous, scandalous, or vexatious matters that are discovered by the court in the pleading shall be amounted to the striking out consequence. The principle and the process of striking out pleadings can be seen in this case. This case was initially discussing about a rightful ownership of a land located in Kuala Lumpur back in 2014, which later was brought into a pleading proceeding as it involved a bona fide purchaser. Facts of the case is that the plaintiffs claimed that the legal owner of the land was their deceased mother, Wong Su. 3 years before Wong Su died, a legal proceeding was brought against her by the first defendant in this current case, who was by that time an appellant. Back then, Limoy was claimed to be the rightful owner of the land, and an order of transfer has been delivered for the land to be transferred to her. Thus, Limoy was eventually registered as the legal owner of the land, pursuant to the declaration to the judgment in default. Few months later, Limoy transferred the ownership to the second defendant through the selling of the land, and then due to an execution of sale and purchase agreement, the second defendant transferred the ownership of the land to the third defendant, who was the buyer. Back in the current times, as accordance to a grant of probate, a notice of petition was filed by the first plaintiff to set aside the judgment in default that was granted to Limoy. Later, it was permitted by the court for striking out, and the ownership of the land was acknowledged upon Wong Su, the deceased mother. The decision was found unfair by the third defendant, who then pleaded to the court. The arguments by the plaintiff is that the plaintiffs believed that there was no valid title acquired by the three defendants, resulting to the invalidity of the judgment in default. Plaintiff's deceased mother was contended as the legal owner of the land. The land was held by the defendants, who were acting as trustee to the plaintiffs. Lastly, it was contended that any deed of the land shall not be entitled to the defendants. Arguments by the third defendant is that the ownership shall be valid, as the judgment in default has already been granted to Limoy, and transfer of the land was eventually took place. It was discovered that the land was illegally owned by the second defendant and was free from encumbrance. It was then acknowledged by the third defendant how absurd the fact that it took 2 years for the plaintiff to strike out the judgment in default. The third defendant purchased the house with no knowledge of past history and with valuable consideration, then it shall be acknowledged as bona fide purchaser. Hence, the third defendant was strongly objecting the striking out of the judgment in default earned by Limoy. These are the three issues found in this case. First, whether there is reasonable cause of action or defense in the pleading. Second, whether there is presence of scandalous, frivolous, or vexatious in the pleading. Third, whether the process of the court may be abused by the pleading.
My name is Yong Chi, matrix number 253027. I'll be presenting the judgment parts of this case. The court opined that the pleadings have clearly shown that the plaintiff has a reasonable cause of action in this case, as the plaintiff's mother, who is a landowner, has a legal interest towards its sale. However, all the transactions took place were without the knowledge of the plaintiff's mother. The claim made by the plaintiff could not be struck out by the third defendant, as the legality and validity of the transfer made to the first defendant requires a mature consideration by the court. In the case of Bandar Builder Sendram Berhad and others against United Malayan Banking Corporation, the court held that a case can only be dismissed summarily when a claim can be seen obviously unsustainable. It will be considered as unsustainable if after perusing the documents, it's shown that the party has no cause of action towards the same matter. With the reference to the case of Siva Rasa Rasia and others against Chair Hamza, Chair Ismail and others, it was held that an application should not be simply striking out if it requires a deliberate consideration and the oral evidence of the witnesses during the trial in order for the court to resolve the doubt. In short, as there is a lot of issues of law that need to be tried by the court arose in this case. Therefore, this case shall not be striking out. Next, the element of Order 18, Rule 19 1b does not exist in plaintiff's claim. as purported by the first defendant. Plaintiff's father are the one who entered into the SMP transaction. However, it's impossible for the father to receive the money released from the loan agreement between the late mother of plaintiffs and first defendant, as he has no privity of contract. With the reference to the case of Media Industry Syndrome Berhad and others against RNC Mali Malaysia Syndrome Berhad, the court held that the word frivolous or vexatious means a case was brought without a reasonable cause of action and good faith, which is merely for the purpose to embrace the opponent. Hence, the claim brought by the plaintiff could not be said as scandalous, frivolous, or vexatious. This is because the quick rent and assessment of the said property were paid by the plaintiff and her mother all this while. Hence, it's reasonably believed that it was duly registered under their name.
Hi, my name is Lin Chio Hong, matrix number 253161. Now I want to discuss the judgment in relation to the issue of abuse of the process of the court under Order Acting Rule 19 Sub 1 Sub D. The term abuse of the process of the court has been defined in the case of Godfrey Sarali Limited versus Sia Kyong Tek and another, where it means that the court is avoid any improper use in the court process and it must not be used in mala fide with collateral purposes. In our case, the plaintiff reasonably believed that there consists of illegal transaction of the property from first defendant to second defendant and eventually transferred to a third defendant. The court also found out that the plaintiff will never try to persecute any party in this case, since they truly believe that the owner of the property was belong to them instead of any other third party. Besides, the court has also referred to a case of Harapan Permai Sdn Berhad versus Sabah Forest Industry Sdn Berhad. The judge in this case clearly mentioned that it was unsound to conclude that the plaintiff claim was an abuse of the process of the court by merely reliance on the issue of intention and purposes. This is because the issue of intention and purpose requires mutual consideration of oral evidence in respect of the issue and facts. So back to our case. Since the plaintiff were acted in good faith without any mala fide intentions, therefore the court concluded that there is no abuse of the process of the court. The applications of the defendant to shut out the pleading of the plaintiff was therefore dismissed with cause. Thank you.
Hi, my name is Ahmad Naban Haras Muzukifli, matrix number 255906. Moving on to the next part of the presentation, commentaries and analysis. As we all know that striking out application is a way to dismiss a case without going to a full trial. With that being said, in the case of Abu Bakar bin Haji Yusuf, the judge states that a case of striking out application cannot be based on the fact that the case itself is weak. Therefore, whoever wants to resort to striking out application must at least fulfill one of the four elements stated under Order 18, Rule 19. First, it discloses no reasonable cause of action or defense. In the case of Seruan Gemilang Makmur, the judge believes that the claim made must be obviously unsustainable. And the word unsustainable used is referring to the question of whether a case has its cause of action or not. In this case, the judge believes that there is a relevant cause of action, bearing to the fact that the transfer of property to the defendant was void ab initio due to the JID granted from the previous case. Moreover, striking out is a summary process and a drastic remedy, as mentioned in the case of Tractors Malaysia. The Honourable Judge must be really careful in giving his judgment, and upon analysis, in this case, the judge really gave its careful thought in giving the judgment. This can be seen whereby the judge blocks the striking out application that would open to a lot more issues to be tried, such as whether there was an element of forgery in this case, because the plaintiff itself does not have the knowledge that their own properties were being transferred. Had the striking out application is allowed, there will be no trial to be conducted, and therefore the plaintiff will not have its justice served on their own land of dispute. Suborder B, it is scandalous, frivolous, or vexatious. In the case of Ng Ni, the judge defined the word scandalous as wholly unnecessary and irrelevant, And in the case of media industry, the words frivolous and vexatious refer to a groundless action or statement with no prospect of success. A party who wants to resort to this sub-order must believe that the claim made by their opponent is vague and unnecessary, and they have no strong evidence to affirm its claim. And in this case, the judge were convinced that there were nothing scandalous, frivolous, or vexatious in this case because of two reasons. First, plaintiffs were honestly unaware that the property is being transferred because the plaintiff paid the pit rent. Secondly, the will made by their late mother, informing that the details of the properties were actually owned by them. Both proofs were obtained via plaintiff's affidavit in reply. And the difference between Order 18, Rule 19, Sub-Order A with the three orders is that the court may look onto affidavits of the case before deciding whether the pleading could be struck out or not.
Hi, my name is Ahmad Shami, metric number 255692. Now I'll proceed with subparagraph C, where a pleading may be struck out if it may be prejudice, embrace, or delay the fair trial of the action. Actually, this ground was not included by the third defendant in this case, but we believe that it is good for us to discuss, as this subparagraph also is one of the ground of the striking out the pleading. We may refer to the case of Lau Xiang Ko, where it is stated that this ground is a fact-based and thus the defendant need to establish fact in order to use this ground. They also need to show that it may causes a real risk of prejudice to them in order to conduct a fair trial. Next, we move to the subparagraph D, where the third defendant here had applied in his application. It is stated that it is otherwise an abuse of the process of court. In the case of Godrej Sarah Lee Limited, it is defined this ground as an action that was not bona fide, but for some other ulterior or collateral purpose, and the important thing is that it includes consideration of the interests of public policy and justice. In our case, actually, we agreed with the judge in deciding that the plaintiff have no mala fide intention at all. This is because due to the process of the defendants in transferring the property, raised doubt on its legality, and thus we believe it can be questionable. We believe also that the plaintiff had acted in good faith to clear the doubtful, since their late mother also did not aware with this matter of the transaction. Furthermore, the judgment in default also was set aside. We may refer to the example of the abuse of process in the case of HBI, like stated here. And next, in the case of Harapan Permai Sdn Bhd, it is stated that the intention of the party require a major consideration before determining it. And as in this case, we managed to see that the third defendant was not able to convince the court in order to use this ground, as the plaintiff had acted in good faith. To summarize all of overall of this case, we believe that the judge has justified every issue and agreement precisely because the relevant fact had been identified by the court very carefully. As we are aware, the strikeout pleading will not easily be granted by the court, and we believe that by considering all relevant facts, the plaintiff will have a reasonable cause of action, and there was nothing scandalous, frivolous, and vexatious, or even no abuse of process of the court in their claim. The highlight statement in this case, we would like to highlight that the court does not intend to close the door of justice for the plaintiff, as if it was found against the plaintiff will not be able to refile the claim in future. So we agree with the court's decision in dismissing the third defendant application to strike out the plaintiff pleading. That's all from us. Thank you.